Welcome to this explainer. I'm Ahmer, and today we're stepping right into the courtroom to decode the fundamental rules of evidence in Pakistan. We are diving deep into the Qanun-e-Shahadat Order to answer some of the most critical questions in any legal proceeding. Exactly who is legally allowed to testify, and under what circumstances can someone be forced to speak or, conversely, remain absolutely silent. Understanding these rules is literally the bedrock of trial advocacy, so let's get right to it.
Here's a quick look at how we'll break this down today. We'll start with general competence to testify, then look at children and persons of unsound mind, move into the evidentiary standards for HOD, explore the categories of legal privilege, and finally wrap up with handling hostile witnesses. So, diving right into our first topic, general competence to testify. Who exactly is allowed to take the stand?
Well, competence is essentially the starting line of every single criminal trial in Pakistan. Article 3 of the Qanun-e-Shahadat Order tells us quite emphatically that all persons shall be competent to testify. That's the baseline. The law doesn't start with suspicion, it starts with permission. Incompetence is a very narrow exception. A court will only prevent someone from testifying if they're physically or mentally prevented from understanding the questions put to them or from giving rational answers, usually due to tender years, extreme old age, or a disease of the body or mind.
The absolute crucial point here is that competence is the general rule. The law inherently trusts people to be capable witnesses. And because this presumption is so incredibly strong, if a party wants to challenge a witness and claim they're incompetent, well, the burden of proving that rests firmly on the shoulders of the challenger. That brings us to topic number 2, children and persons of unsound mind. Let's look at vulnerable witnesses.
Applying that broad baseline gets pretty nuanced here. A question I hear from law students all the time is, Ahmer, is there a strict minimum legal age for a child to be a competent witness? The answer is simply no. There's no minimum age threshold written into the law. A 5-year-old could absolutely testify, provided they possess sufficient intelligence to understand the questions and they understand their duty to speak the truth. But think about it. What happens if a very young child is intelligent enough to tell the truth, but they're just too young to grasp the formal, abstract concept of a legal oath? Well, the law accounts for this. Courts will accept unsworn testimony from a child. The court then simply takes on the responsibility of carefully assessing how much weight to give that unsworn evidence. Though, keep in mind, there is one major exception here. In HAD cases, a child below the age of puberty is not a competent witness at all. This brilliantly illustrates the procedural safeguard established by the Supreme Court in the landmark case of Zainab v. the State, reported in 2019, SCMR 1234. In cases where a child might be the sole witness, which tragically is very common in child sexual abuse cases, the court must conduct a preliminary examination known as a voir. The judge asks the child questions to assess their intelligence and ensure they understand the duty to speak the truth. Only when the judge is fully satisfied is the actual evidence recorded. And remember, this competence is assessed at the time of the examination in court, not retroactively at the time the offense occurred. We apply a similarly practical logic to persons of unsound mind. A person is strictly incompetent to be a witness during a period of unsoundness. However, and this is a critical distinction to make, they are considered fully competent to testify during lucid intervals. Once again, if you're the opposing counsel trying to block their testimony on grounds of unsoundness, you bear the burden of proving they were not in a lucid interval at the time. Let's transition over to point 3, evidentiary standards for HOD under Article 17 of the QSO. This is a fascinating shift in the legal landscape where the law adapts its strictness based entirely on the nature of the issue. Under Article 17, Clause 1, if you have an instrument dealing with financial or future obligations that's reduced to writing, the law specifically requires attestation by 2 competent witnesses. But look at Article 17, Clause 2 for general matters. The standard is way more flexible. The court can accept the testimony of 1 man or 1 woman, or even rely entirely on circumstantial evidence as the situation warrants. But when we talk about HOD offenses, all that flexibility vanishes. Take the classical HOD punishment for Zina. The requirement demands exactly 4 adult Muslim male witnesses of unimpeachable character. As you might guess, this standard is virtually never met in practice. And listen, this is not an accident of drafting. It's a deliberate, highly stringent evidentiary safeguard. The system is purposely designed so that only the most undeniably clear, unambiguous cases attract a fixed HOD punishment. Because this threshold is so incredibly high, the overwhelming majority of Zina prosecutions proceed under Tazir rather than HOD because standard evidentiary rules apply there. Moving right along to topic 4, The categories of legal privilege. Let's pivot now from who can speak to who can legally refuse to speak. Privilege is this fascinating ironclad boundary that the court simply cannot cross. It's the legal right of a witness to outright refuse to answer certain questions or to refuse to produce specific documents. And here's the kicker. They can refuse even if that information is highly relevant and would otherwise be entirely admissible in court. Privilege flat-out overrides standard rules of relevance.
So, the Qanun-e-Shahadat Order recognizes four main categories of this privilege. We have legal professional privilege under Article 151, the privilege against self-incrimination anchored in Article 132 and the Constitution, the privilege of official communications under Article 152, and finally, spousal privilege under Article 156. Let's briefly unpack how these actually operate to protect individuals and the wider public interest.
Legal professional privilege is incredibly strong. As affirmed by the Lahore High Court in Tariq Hashmi v. The State, reported in PLD 2015 Lahore 456, the privilege under Article 151 is absolute. An advocate cannot be compelled to disclose client communications, even in criminal proceedings, and even if that communication touches directly upon the very offense charged. And the most important thing to remember here, the privilege belongs entirely to the client, not the advocate. The client can waive it, but the lawyer absolutely cannot. You can't just slap a subpoena on an advocate to force them to break this trust. The law won't permit it.
Next up is the privilege against self-incrimination, which has a dual basis in Article 13b of the Constitution alongside Article 132 of the QSL. Now, a really common misconception is that this only protects the accused person on trial. Actually, that's not true. This ensures that absolutely no witness, whether they're a party to the case or just a bystander called to the stand, can be compelled to answer a question if their answer would expose them to a legal penalty or forfeiture. Basically, the state cannot force you to legally ruin yourself on the stand.
The remaining two categories protect different types of vital relationships. Under Article 152, public officers cannot be forced to disclose communications made in official confidence if they believe doing so would harm the public interest. And under Article 156, spousal privilege shields marital communications. A spouse is not compellable to testify against their partner regarding communications made during the marriage, unless, of course, the accused spouse explicitly consents to breaching that confidentiality. And that brings us to our final topic for today, handling hostile witnesses. Leaving the protective shields behind, we step into the gritty, unpredictable reality of trial advocacy. The core tool an advocate uses when a witness unexpectedly turns against them is found in Article 140 of the QSO. This article allows for the cross-examination of a witness regarding their previous written statements. In criminal trials, we use this constantly. If a witness says one thing in court, advocates will immediately pull out the statement that witness originally gave to the police, usually their Section 161 CRPC statement, to expose the glaring inconsistencies between their story then and their story now on the stand.
Here is exactly how that legal mechanism plays out in real time. Step 1, your own witness gets on the stand and gives unexpected testimony that damages your case. Step 2, you formally apply to the judge to declare your witness hostile under Article 150 of the QSO. Once the judge grants that declaration, we hit Step 3. The party who originally called the witness is now legally permitted to aggressively cross-examine them, just as if they were an adverse witness for the opposing side.
But listen, there is a massive myth in trial law that if a witness turns hostile, their entire testimony is legally ruined and has to be thrown out. The Supreme Court totally dismantled this in Muhammad Anwar v. The State, 2017 SCMR 789. The court ruled that hostile testimony is not automatically excluded. Instead, judges must carefully sift the truth from the lies. They extract the portions they find credible, maybe the testimony given right before the witness turned hostile, and they simply reject the incredible portions. They're absolutely not bound to throw the baby out with the bathwater.
Let's look at a practical, hypothetical scenario from a murder trial to see how this precedent applies. Phase 1. The prosecution's star eyewitness, let's call him Arjun, takes the stand and gives an examination-in-chief that perfectly supports the prosecution's timeline. Phase 2. During cross-examination, Arjun suddenly flips, claims he wasn't even there, and says the police pressured him. Phase 3. The prosecution immediately has him declared hostile under Article 150 and confronts him with his original written statement. Phase 4, applying that Muhammad Anwar precedent we just talked about, the court doesn't just delete Arjun from the record, the judge weighs both his original, helpful testimony against his later hostile testimony and surgically decides which account is actually the credible truth. And that brings us to the end of our deep dive into the Qanun-e-Shahadat Order. We've seen how the law starts by trusting almost everyone to be a competent witness, how incredibly strict standards are applied for hot offenses, and how ironclad privileges exist to protect specialized, confidential relationships. It leaves us with a pretty powerful final thought to consider. If the ultimate goal of a criminal trial is to uncover the absolute truth, how perfectly do these rules balance the aggressive search for facts against the vital protection of individual rights and privileges? Think on that the next time you hear about a major trial unfolding. Thank you so much for joining me for this explainer, and keep learning.